Hello everyone, welcome to Steno Aspirants. I am Akshay and I am going to dictate you Rajasthan High Court judgments containing 720 words at the speed of 90 words per minute. The dictation will fluctuate between the speed of 85 to 95 words per minute. So get ready. 3 seconds. Start. The respondents, writ petitioners, the bank officials proceeded to confirm the sale under auction dated 28 to 2018 on 26 for 2018 and also issued sale certificate accompanied with delivery of possession of immovable property of the writ petitioners stop. It would thus be clear that no hearing on stay application, much less effective hearing, had taken place on the prayer for stay made by the writ petitioners, and the case was adjourned for filing a rejoinder on 20 2018, and immediately thereafter the sale was confirmed and sale certificate was issued and possession handed over stop. It was clearly an act of overreaching the order of the court stop, as has been observed herein above. The spirit of the order of the court was that till stay application is heard and decided, interim protection would continue, obviously because the court was of the view that at least till hearing and decision of stay application, the sale should not be confirmed. Otherwise, the very prayer for stay would be rendered infructuous stop. It was a matter relating to sale of immovable property of the writ petitioners stop. The protection was granted wide order dated 25/1/2018 by the writ court, taking into consideration the willingness shown by the writ petitioners to settle all the dues stop. Apparently, bank officials were in a hurry for the reasons best known to them stop. They were parties to proceedings before the DRT on various dates of hearing, and it was within their personal knowledge that no hearing on stay application had taken place, much less any order passed stop. Order dated 25/1/2018 was clearly intended to protect the writ petitioners till hearing on their stay application stop. The order could not be construed narrowly, meaning thereby that some kind of proceedings takes place without any order passed, as that would be completely absurd stop. In any case, as has been referred herein above, even no hearing on stay application had taken place, and on various dates pleadings were exchanged, directions were issued for supply of applications, filing of rejoinder, etc. Stop. Up till date of confirmation of sale on 26/4/2018, none of the orders has reflected from various orders. Seats of the DRT would show that any argument whatsoever towards hearing of stay application was made by the parties stop. Even hearing had not taken place stop. Therefore, the contention of the appellants that as the hearing had taken place, therefore the protection granted wide order dated 25/1/2018 came to an automatic end, has no legs to stand, and if we may say so, is deliberate misreading of the order and completely frivolous. Stop. If the pleadings of the appellants contemners are read in juxtaposition with order dated 13 for 2018 of the registrar DRT, it would be clear that hearing of the case was preponed on the prayer made by the bank. Stop. When the case was again listed on 16 for 2018, no hearing had taken place, but only direction for exchange of pleadings was issued. Stop. It was not even hearing before the DRT, but the case was listed before the registrar DRT for fixing the case for hearing. Stop. When the matter came up before the DRT on 20 for 2018, the case was listed for filing of rejoinder before the registrar on 24/5/2018. There is no whisper in the order that any hearing had taken place, much less any order passed on the stay application. Stop. The appellants have also taken stand that when the order granting protection to the writ petitioners was passed by the writ court on 25/1/2018, it was clearly in relation to auction which was scheduled on 30/1/2018, but that auction having not materialized, new schedule of auction was fixed by issuing fresh notice fixing date of auction. Auction was held, sale was confirmed, and sale certificate was also issued. Stop. Therefore, it is argued that it was not within the ambit of order dated 25/1/2018. Stop. This argument deserves to be rejected at the threshold. Stop. The writ petitioners had approached the court because the bank had initiated proceedings to auction their immovable property, and their application for stay, though pending, was not being heard. Stop. Merely because at the time when the order was passed on 25/1/2018, the auction was fixed on 30/1/2018, does not by any stretch imagination mean that if on that day auction could not take place. Stop. Over.